Good evening, class. It's about 23:18 over here on the West Coast. Now, for our video discussion this week, I chose to speak about the Scopes trial. So to begin, the Butler Act of 1925 was passed in the state of Tennessee, and now this forced educators to recognize the teachings of the biblical account of mankind's origin, and it strictly prohibited the teaching of evolution. Now, at this time, that was a huge win for those that opposed Charles Darwin's theory on evolution. Now, following the passing of this bill, the topic of evolution would once again surface as a teacher by the name of John Scopes would be accused of teaching evolution to his students. Now, backstory of John Scopes, he was a teacher, he was a physics teacher and a math teacher. And the allegations are really stemming from his short period of time in which he substituted as a biology teacher and gave his students a pamphlet or work of some sort that really focused around evolution. Now, the trial that would subsequently be known as the Scopes trial or the Scopes monkey trial was more than the prosecution of a man who violated the law. Instead, this was ultimately a platform that provided pro-evolutionists to speak out against the legitimacy of the Butler Act and argue against the anti-evolutionist claim to the legitimacy of Charles Darwin's theory. Now, the two men that would lead the council in this case would be anti-evolutionist and really a pretty good politician, William Jennings Bryan, and his nemesis, Clarence Darrow, a famous attorney in his own right, whom they've kind of butted heads in the past. Now, the first article that I chose to recognize is the New York Times article that was published July 8th, 1925, and it's titled, Bryan and Dayton Call Scopes Trial Duel to the Death. Quite the name, really catching. And it provides an idea of the growing sentiment towards the ultimate subject of evolution. Now, in this article, they use phrases like, if evolution wins, he declares, Christianity goes, for both cannot survive, and sees the Bible at stake. Now, these are obviously quotes from William Jennings Bryan, and they're coupled with the article really speaks to, upon his arrival, they're just cheering. The crowds are cheering. And I really believe that this speaks to the overall sentiment towards the topic of evolution. Now, the article follows him from his arrival to, as I said before, cheering crowds, to the overall preparation of his intended speech, in which he would declare that pro-evolutionists do not have strong enough evidence in which to destroy the Bible. So it almost sounds like his argument is that pro-evolutionists are attacking what the Bible stands for. Now, in this article, Bryan uses words like foe, i.e. enemy, and gives evidence that he believes this is a battle or struggle between Christianity and all others, to include atheism and agnostics. He does recognize that in the article. Now, going forward, as you can imagine, this was a well-publicized trial that brought a lot of attention from the general community. Clarence Darrow would lead the opening remarks with a very passionate speech that would describe the act, or the Butler Act, I should say, as illegal, since it was very specific to just simply singling out evolution. Whereas Bryan, he would take the stance of chastising evolution for suggesting that humans were but one of 35,000 types of mammals, or that we could come from not American monkeys, but world monkeys. Now, the trial would ultimately become a heated battleground between both Darrow and Bryan, and on the seventh day, Darrow would eventually question Bryan's knowledge of the Bible as he was placed on the witness stand. And as we know, Bryan would admittedly say that he is not that knowledgeable in biblical scriptures, history, etc. Now, the second article I chose to examine is the Nome Nugget, which was written on July 18, 1925. And in this article, it covers the testimony of an expert in zoology and the argument made by Darrow that the prosecution was simply trying to convey what evolution is, but the jury could not form a logical decision without knowing what evolution truly is. Now, Bryan would counter that the only thing the jury needed to decide is whether or not Scopes violated the law. The last portion of this article discusses the point in which the judge, who at this time is largely believed to be biased towards the anti-evolutionists, he barred the scientific testimony on the ground that the case was only about whether or not the law was constitutional and if Scopes had in fact violated the law. The outcome of this case would be Scopes being found guilty. Now, this was really upon the request of Darrow, who understood the uphill battle that would be lost, because he understood, I believe at that time, not only maybe the bias of the judge, but just realized they were not anticipating or looking for any other outcome than to find this man guilty. And therefore he got found guilty and fined $100 in violation of the Butler Act. Additionally, this case would really not have any significant impact on changing the Butler Act, which would remain in place for the next several decades and also attract other states to do the same. Thank you. Have a good night.